Any mentions?
May I please, your lordship?
Yes. Yes.
I'd like to mention item number 32 of the supply list.
Yes.
My lord, we have filed a affidavit of service today in this matter.
Mhm.
Kindly, the record may be called for.
Non-council, Mr. Swanso submits that he has filed affidavit of service in the registry. A report be made on the affidavit and the matter be re-notified for admission, re-notified in the next week. All right. Yes.
Obliged.
Look, I am praying for listing of
Can I make a submission? my lord?
Sure, sure.
Item number 32, where my lord, my learned friend will be appearing, notice has been served. Actually, affidavit was for the purpose of my lord, whether my lord notices has been served or.
So
all
you are
that I
appearing,
was- all that
you
I
are
was-
appearing for the appellant
Yes.
to respond.
And my learned friend for
I'll
the
be
response.
appearing for the workman, my lord.
So you are representing the respondent, then what is the reason for me,
Yes,
for
my
why
lord.
you were to
yes.
file an affidavit?
No, my lord, there was an order that.
No, no,
the-
why he is to file an
No, my
affidavit?
lord, he's not filing. For my junior.
You have filed, all right.
So what I'm praying for him, my lord, let the matter be listed.
You are for the
admission.
management
Yes.
and he's for the workman.
No,
Yes.
he.
You are
my
there.
learned friend.
So all right, service is complete then. Let it go for admission.
That's all.
All right.
Next week, my lord.
As stated by learned counsel for the parties, comma, service is complete.
My lord,
List.
there is delay of 3 days, my lord.
So
That's
No,
why.
that
notice-
should we, what do you say on the delay
1 or 3
connotation?
days I don't have any.
All right, I have for delay connotation allowed. List for registry shall number the up connected appeal and list the same
Next week.
for
my lord.
admission next week.
Deep level.
I am praying for listing of a matter. It's impossible for motion tomorrow, my lord. But there is a surface eye application that we have filed in the DRT.
Mhm.
Presently, the presiding officer is on leave, my lord, till 30th of April. Can
Okay,
be taken up by lordships tomorrow, my lords.
tomorrow, very well. Yes.
May it please your lordship. Lordship, I have filed a read appeal on 10th April of this month.
Mhm.
So may I pray for listing of the same your lord, admission next Monday?
Next Monday, all right. List it
Obliged.
next Monday.
Wait, this is Roshik. My lord, a writ appeal has been filed today, my lord. There is urgency is there, my lord.
What is the urgency, sir?
Tender matter, my lord.
Tender matter,
Tender
all right.
matter last-
Day after
yesterday-
tomorrow.
Yesterday was the last date, my lord. Probably they are going to settle the.
So yesterday, what, we can't turn the clock back into time, na? Day after tomorrow,
Tomorrow, my lord.
day after, tomorrow, all right,
My
tomorrow. Okay,
Obliged, my lord.
yes. Any more mentions? No, all right. I just, I'm making. Which matter you are talking about? Hearing now? So, all right, so we'll just let the members of the bar be informed that there are few hearing matters listed at top of the list. So any of the lawyers who have extreme urgency in the other matters may make a mention, because once we commence with this hearing matter, there will be no more admission order cases. So if there are matters of extreme urgency, we'll give you 5 minutes to get organized and make a mention. And Mr. Saab, this matter will continuously list it at 2 o'clock every day henceforth.
My lord, the reservation matter which your lordship has fixed.
From 19th onwards, my lord.
From
19 onward, yes.
Today, since the other matter will take some time,
And
so we'll not bother your lordships
So
today.
we can, what we can do is we can spill over the remaining matters tomorrow and day after tomorrow.
Day after- day
So
after
the entire list,
Day after tomorrow.
day after tomorrow.
Day after
Items number 19 to
19 to lordship.
31, day after
31.
tomorrow. These will come up on
Day after.
today is 25th.
Supplementary provision.
27th to 29th. These will come up on 27th.
Yes.
or 27th.
Supplementary list also, my lord, some matters are connected with these cases.
This one,
In the supplementary
Yeah.
list.
36 to 41 again, day after tomorrow.
They also come together.
Yes, 27th. Yes.
And next Tuesday,
I can, my lord.
Who?
They listed, can it be day after? But if not,
Day after. Who's there for the other side?
my lord, my friend is there and my senior. is.
Item number 2, day after tomorrow.
Day after tomorrow. Pavitra Bora. Matsumi.
Day after tomorrow.
My lord, that reservation series, could it be on Tuesday, my lord? I find, my lord, there are many fixed matters that are on. that.
Tuesday means 3rd.
Second, my lord.
second, we feel that you can have it on third rather,
Okay, my lord.
third.
Deeply observed.
They will also go on third May.
May I please, your lordship?
Yes,
I back to mention daily list item number 18, my lord.
18, yes.
My lord. My lord.
Can we have the urgent mentionings page wise? Page wise. Page number 1, anyone on page number item number 1 to 1 and
Item
2.
number 1 to
Who
5.
is already adjourned? No, item number 1. Who is there in item number 1?
For item number 1.
Yes.
To inform the court that after my issuance of notice, my lord, already the my two children have been recovered by police, my lord.
What has been taken over?
Particularly, my lord, this case relates to my lord recovery of children who went missing, my lord, and the police
Children have been traced out.
traced out, my lord.
So
And
this has become infructuous.
yes, sir.
Learned Counsel for the petitioner states that during pendency of this writ petition, the missing children have been traced out and thus the matter has become infructuous. Mr. Nath has placed on record a factual report forwarded from the office of the SP so and so in affirmation of this fact. In view of the situation noted above, the instant writ petition criminal is disposed of as infructuous. What is the pursuant to whom the custody has been given?
Father, yes, father. Petitioner is
And the custody of the children has been handed over to the petitioner being their natural guardian father. Dispose of infructuous. Okay. Then page number
Page number 2, items 16 and 17.
16, 17. Any urgency, please? No urgency.
17, we have urgency that Supreme Court remand matter, pension matter, lordship.
Okay.
We have
So you
urgency.
can have it day after tomorrow or
Today-
tomorrow?
Today.
Today, all right, today. Come on,
Today.
argue.
Oh.
Item number 17,
Lordship, at 16, Lordship.
16, yes.
Maybe, day after tomorrow, Lordship.
Day after tomorrow, fine. Yes. 17,
Yes, yes.
you are for the respondent, state of Assam.
Appellant advocate was here, he is here.
State, this is state. Yes, come. Remand. What is it about? Yes, let's know. Let's see. This was dismissed on ground of delay. All right.
Yes, my lord.
So delay has been condoned.
Delay has been condoned, my lord. Matter went up to the apex court. The delay was condoned with a cost of rupees 25,000 that has been duly paid to the appellant. Matter here is, my lord, whether the lead petitioner will be, my lord, will come under the ambit of the new pension scheme or whether he will be entitled to the benefits of the 1969 rules.
All right. Mm.
My lord is taking.
His writ appeal is of 2019.
My lord.
Okay.
Here, my lord, what had happened? My lord, way back
So
in the year.
2019
My
is the order of remand related. This has not been taken up thereafter what?
But it has come up on several occasions before this honorable court.
Before the Guwahati High Court, sir,
Yes, my lord.
it has come up
My lord.
many times. All right. Okay, what is the judgment? Let us see the judgment of the single bench.
My lord.
Come. Yes.
Page 234 of the appeal memo.
234 onwards, my lord.
All right. Yes.
My lord, by dint of this judgment, my lord, the past services of the repetitioner has been counted.
In the sub registrar office.
Yes, sir. Right, sir.
So why these services are not to be counted as per you?
Yes, my lord, there is a, my lord, express provision, my lord, in the rules of 1969, which says, my lord, that.
You will have your turn, sir. Don't be so anxious.
He is always anxious. Before.
Yes. Please read the finding of the learned single bench.
My lord, my lord. Lordship may kindly come to page 240.
Para number,
para number 21.
yes. Issue is not of
Issue is
retrospective.
not of retrospective regularization of the services of the petitioner. Question for consideration is whether services rendered by the petitioner as sub-register on commission basis should be counted while computing his pensionable service. In the order dated so and so, the stand taken by the government was that since the petitioner received remuneration by way of commission and not by way of salary, he would not be entitled for pension in view of the provisions contained in Note 2A below Rule 44 of Assam Service Pension Rules 1969.
Mhm.
Now there is a specific bar. Provisions of Assam Registration Rules 2010, which provides for counting of such services rendered on commission basis under Rule 13A, would not be applicable in the case of the petitioner as he was regularized on a prior date with effect from 25/4/2008.
Mm.
Whereas the Assam Service Rules 2010 came into force with effect from 18/11/2010. Now, the petitioner is heavily harping on that Assam Services registration rules.
Mm.
Then Lordship may kindly come to para 23.
Right.
As already discussed above, the core issue which arises for consideration in this proceeding is whether the previous service rendered by the petitioner as sub-register on commission basis should be counted for the purpose of computation of his qualifying pensionable service. This is the moot question which required to be gone into. The Registration Act is an act to consolidate the enactments relating to registration. Here, my lord, the provisions of the Registration Act has been discussed.
Probably to find out what kind of service he was
Service.
performing.
The admitted position is that, my lord, he was appointed way back in the year 1984 on commission basis. Now, the South Registration Act 1908 does not contemplate any situation whereby a person can be appointed on commission basis. Nonetheless, he was appointed, he happily carried on with his job. Now, my lord, in the year 2008,
Appointed means appointed by whom?
my lord, appointed, my lord, by the Deputy Commissioner with sanction of the government. Because there was, my lord, a need of a sub-register. However, my lord, since the infrastructure was not there, so he was allowed to, my lord, carry out his duties
On commission. The
basis.
commission received on the registration charges.
Yes, commission
Alright.
received on the registration charge.
Right, okay.
Now thereafter, my lord, prior to 2008, the
Mhm.
infrastructure came to be built, my lord, came to be existed. And my lord, in the year 2008, his services came to be regularized. Now, in the meantime, my lord, with effect from 1st of February 2005, the new pension scheme promulgated by the state of Assam has come into effect.
So your case is that his services for all purposes will be counted from 25/4/2008 and the earlier services will not be,
Not be counted.
yes, all right.
Because of the two primary reasons, he has given an undertaking, he has accepted the service with an undertaking that he will abide by the new pension scheme. And the
Okay,
deductions under the new pension schemes were already made. My lord.
Already
He has
made.
not put to challenge anywhere, my lord, at any point of time.
where is that aspect dealt with?
Yes. Lordship may kindly come to para 31. At page,
31.
yes, page 244.
Mm.
From an analysis of the nature of appointment, nature of work differs, and considering the perennial nature of work, it is evident that there is a master and servant relationship between the sub-registers working on commission basis and the state. Viewed in the above context, there is no justifiable reason to exclude the work and experience rendered by a sub-register on commission basis for the purpose of computing qualifying pensionable service after he is regularized and brought into regular cadre of sub-register. In such a case, the fact that commission was paid for an earlier period of service rendered instead of salary would not make any material difference.
Mm.
Then, my lord, the penultimate paragraphs, my lord, at page 247, the last page of the memo, my lord, para 33 and 34.
Mm.
Thus, having regard to the discussions made above, claim of the petitioner that the services rendered by him as sub-register on commission basis.
Mr. Counsel,
My
this para 15,
lord.
that is reproduced from where? 31 within para 31, there is a para 15
Yes,
on the penultimate page of the judgment.
yes.
Where does that come from?
My lord, this is in, my lord, extract, my lord, of the of an earlier round of
Earlier round of
earlier
litigation,
litigation, my lord, where the order has been passed.
wherein the finance department had agreed to consider his case,
Agreed, my lord, later on upon examination, my lord, the finance department has rejected.
has
In-
rejected.
Yes, in view of the specific provision of the new pension scheme.
All right.
Now, my lord, if my lord takes up the new pension rule, my lord, the pension rules of 1969.
Will you
for a
please
moment,
read para 29 first?
para 29.
Yes. How do you get out of this judgment?
Yes, my lord. Referring to the said decision in connection with Dr. Supra, Supreme Court in the case of Chandra Prakash Pandey did not interfere with the decision of the Allahabad High Court that Purk Amins, appointed on commission basis for recovery of outstanding dues of the cooperative societies, were members of the service and the government servants. It was held that Purk Amins, appointed on commission basis, stand on the same footing as that of Purk Amins, appointed on salary basis, in whose case it was held that they held civil posts and entitled to regular scale of pay. Now, there, my lord, the honorable, the appeals court had the occasion, my lord, to examine the issue in the state of Uttar Pradesh, my lord, where these Amins were appointed. Now,
The
they
issue
were,
which was decided was, what is the nature of job? Is it perennial in nature or it's a temporary job?
absolutely,
The same thing has been held here. Now, what argument you were advancing regarding he having given an undertaking? Where is that argument before the single bench?
my lord, that argument was there, my lord.
Read, please.
My lord. Lordship may kindly come to paragraph 18, my lord, 238,
1-8.
my lord, 1-8. Paragraph 18, my lord, at page 238 of the memo.
Yes. Hmm.
While so and so learned counsel for the petitioner argued that service rendered by the petitioner as sub-register and commission basis.
Sir, undertaking
My lord,
to be governed by the new pension scheme.
but that argument was specifically not there.
Read in the memo of appeal.
Yes. In the memo of appeal, it is there, my lord.
Let's see.
My lord.
And before that, you will have to satisfy that this was your stand in the affidavit filed before learned single bench.
My lord.
Let's see that. You want to exclude him on account of some undertaking, then read that
My lord,
pleading.
Yes, undertaking, of course, is one aspect of the matter. Otherwise, he is statutorily barred under the rules. Rules of
That
19
rules which came into force in 2010.
No, the prior rules, because he is claiming his entitlement to the prior rules.
Okay, prior rules, what do they say?
My lord, prior rules, my lord, if lordship takes up the Assam Service Pension Rules for a moment, my lord.
Manual.
Assam Service Pension Rules 1969.
Yes,
Lordship will kindly come to Rule 44.
rule 44.
Rule 44.
Yes,
A person, in order to establish that he is entitled under the rules of 1969, would have to, my lord, satisfy the conditions laid down.
let's see, let's see.
Now, in that forthcoming decision, my lord, with all respect, my lord, these aspects of the matter, my lord, the rules of whether similar rules existed in the state of.
Read.
Yes. Rule 44, my lord, consolidated fund of the state. Down below, lordship will find note 2,
Hmm,
rule 44. There are two notes, my lord, note 1 and note 2.
hmm, hmm,
Note 2 says, my lord, the following are not pensionable service.
hmm, hmm.
Here, my lord, will kindly come to clause 4, Roman 4.
Fees or commission, government servants who are
Yeah.
not in receipt of pay but are remunerated by
Fees
fees
or
or commission.
fees or
Yes,
So there is the exclusion, my lord.
right. This rule has been considered in this single bench judgment.
Yes, it has
Where?
been considered.
Where?
Yeah.
Where?
Well.
Read out. How does the learned single judge deal with this exclusion clause?
Yes, my lord.
Rule 44. Read, please.
Yes, my lord, I am coming, my lord.
Page 244, paragraph 31.
Yes, my lord. Paragraph 31, my lord, page 244.
Yes.
From an analysis of the nature of appointment, nature of work discharge, and considering the perennial nature of work, it is evident that there is a master and servant relationship between the sub-registers working on commission basis and the state. Viewed in the above context, there is no justifiable reason to exclude the work and experience rendered by.
So as on the date when he laid his claim for pension, he was not receiving commission. He was receiving pay. So the issue only is whether the past services are to be counted or not.
Yes, no,
So this rule doesn't exclude the counting of the past services,
no, this
which
rule-
is the provision which excludes the past services.
My lord, the exclusion, my lord, provision is to be called out, my lord, with a harmonious reading of this rule, as well as, my lord, the new pension scheme with that undertaking.
Mm. But undertaking part, there is no pleading, sir.
Pleadings is not. there,
So
but
then how do they reply to that?
No, my lord, he
read-
will be stopped. He will be, once I give an.
All right, read your appeal, memo of appeal.
Yes,
Where is your affidavit in opposition? Read that from affidavit in opposition.
yes, my lord.
That argument was never advanced. How can you be permitted to raise this argument now?
No, my lord, lordship will kindly come to, my lord, see, my lord, paragraph 31, how the landed single judge has, my lord, negated that argument, my lord. It
Dear
was
sir, you are arguing now. That argument we have seen
Right.
regarding applicability of 44.
my lord.
We'll see about that later. First, you are arguing about undertaking.
Yes, my lord.
Let us see your pleadings.
Lordship may kindly come to, my lord, page 181,
181.
my lord.
If that's your affidavit,
Yes, my lord.
yes.
There, my lord, will kindly come to page 182, my lord, internal paragraph 4 of that affidavit.
Mm.
It is pertinent to mention here that after having examined the case of Mohammad Hussain Ali, that is the writ petitioner, retired.
You are
service-
reading it, Para?
My lord, for internal paragraph 4.
Yes. Yes, after having examined.
Yes, my lord.
Yes.
It is pertinent to mention here that after having examined the case of so-and-so retired sub-registrar for refixation of his
Dear
salary.
sir, where is the pleading that he has made an undertaking? So he is not entitled to claim.
My lord, that is specifically not there.
So
but-
that is not there. You are not permitted to raise it now.
No, my lord, subsequently, my lord,
Stopped.
lordship may kindly come to page 206.
206.
206,
If it is there in your order, yes, we can quite
my lord,
see that. Yes, 206.
206.
Do your order state that he has given an undertaking?
Yes,
All right, 206. Read.
and there is a speaking order, my lord, passed by the department.
Let
which
us
said-
see now. Let us see.
My lord,
What is 206?
206, my lord, is the affidavit filed by the finance department.
Yes, read.
There, my lord, will kindly come to internal paragraph number 3 at page 207.
Mm.
The department begs to state that the finance department, after in-depth examination, arrived at the decision that there is no provision in the fundamental rules and subsidiary rules to allow the claim of the petitioner.
Your only case is that he did not apply for regular selection,
My lord,
so he is not entitled. Where is the pleading regarding undertaking, sir?
that is not specifically there.
So that is not there, then you are not permitted to argue that.
But,
That was not your case before single bench.
but that is the admitted position, my lord.
Maybe you are required to have it adjudicated by the learned single bench.
Lordship may kindly come for a moment to page 50. I'm trying to satisfy my lord.
50. Read from your speaking order whether this
Yes,
is the
yes,
ground.
Yes, page
Read.
50, 50,
Yes.
page 50, my lord.
Mm.
Precisely, my lord, the findings are at page 52.
Mm.
Page 52, the last paragraph, my lord.
Yes.
Taking into consideration the views of the finance so-and-so department and pension and public grievances department, the claim made by the petitioner now so-and-so with regard to refixation of his salary and
That is
seniority.
only what this order conveys is that his services are governed by the new pension rules.
Yes,
Where is the fact regarding undertaking, sir?
the undertaking it is down below, it is there, my lord. Further, as the services of so-and-so as sub-register was regularized on so-and-so and all posts created after 1/2/2005, that is the cutoff date, my lord, do not fall under the purview of the Assam Service Pension Rules 1969. His claim for pensionary benefits under the above pension rules cannot be entertained. Again, payment of pension to him under the new defined contribution scheme is applicable for employee joining after 1/2/2005. Also cannot be entertained as he has not rendered service for the.
Mr. Counsel, Are we not clear enough? You thrice argued undertaking, undertaking, undertaking.
It is not there.
Where is the undertaking?
It is not there.
It is not there, then all right, don't raise such arguments. Don't waste the time of the court.
But that.
So your only argument is 44-2.
44 to, and that undertaking I have annexed it.
Maybe that was not the argument before single bench. Then, yes, undertaking you took because he joined the service thereafter. That is a pro forma provided. So what of that?
No, he accepted
All
it.
right, let's hear them. Yes. What do you say, sir?
My lord, I have filed a detailed affidavit in opposition.
Mhm.
I can
In the
take
appeal,
it
in the appeal.
In the appeal.
Read, please. What do you want to refer
And a
from that?
written argument also, I submitted one set of case law on 12/12 to the.
You don't want to advance oral arguments or what?
Lordship, they have make a ground in their appeal memo that my post is not, it was not a substantive appointment.
Hmm.
Kindly see my appointment.
Where is
My
it?
appointment was by Deputy Secretary, Revenue Registration Department. This is at page 28 of my affidavit, 23, page 31, Lordship. It is a regularization order. Initial order is
Page number
page 26.
31.
Page 26 is my initial appointment. Annexure one
Page 26 of what?
of my affidavit in opposition.
Is there a pagination in the appeal? What is the running page number?
This is affidavit in opposition.
In the appeal.
Running page number, page 26.
Is it in the appeal or in the
Yes,
writ
yes,
petition?
It is my affidavit in opposition.
Sir, you have filed the affidavit in the appeal?
Yes, in appeal.
All right.
In appeal, in appeal.
All right. Yes.
This is
Okay.
my.
Para,
in-
you are reading at page number?
Affidavit, fact of the case,
Oh, which document are you referring to?
page number 2, para 4 of my affidavit. And document is at page 26, annexure 1. This is my initial appointment. Page 26, my lord, annexure 1.
Just hold on.
Lordship got it? Yes.
Trying to locate it, sir.
Lordship.
What is the date of the order?
Order dated 28 April 1984.
28th April. Notification.
Yes,
Order by the governor.
yes.
Yes.
So I was appointed by the Deputy Secretary to the Government of Assam Registration Department.
You are appointed by the governor. That
Yes,
order, that is
Lordship.
simply a communication
And,
by the
Counsel
deputy
for the
registrar.
other side said that I was appointed by DC. Last law.
You are saying so, sir.
No.
The order, read the heading of the order
Yes.
by the governor.
Subject to discharge at the discretion of government without notice and without assigning any reason thereof, Muhammad Hussain Ali, son of
Now, where is the order of regularization?
Lordship.
Where is the order of regularization?
That is page 31, annexure 3. My initial service was regularized.
Let's see, let's see.
Regularize the service. That was
So it's
wording
not a
has
fresh
been-
appointment.
Not
It
a
is not
fresh
an appointment.
That is the whole case. That's why, my lord, I am covered by Rule 31 of the 1969 Old
We'll-
Pension Rule.
We'll read that
That is the
also.
whole case.
But this regularization order says with effect from date of creation of post. So how can you relate it back to your original date of appointment? Did you challenge this order
We have challenged in our writ petition, in our.
after
pleading.
retiring? After retiring,
It is not a matter of challenge. My,
you
whether.
you are required to say, how can you qualify my service only from the date of creation of post? I was a regularly appointed employee. This goes against you, sir.
My lordship, rule says,
Which rule?
2010 rule,
Yes.
that I ought to have been regularized after 8 years of commission basis service. So,
Rule which rules?
2010 Assam registration service rule. That is in our affidavit in the learned single, before the learned single that we filed it. So earlier there was no service rule in the registration department.
There was no service rule
No
at all.
service rule. That is
All
our
right.
pleaded case.
All right. Now one query. Any of your peers, Mr. Counsel, any of your peers in service, any case of your contemporaries, any case which has come to this court,
No, this is the first case.
or they are waiting in
Because
line?
I retired first.
They are waiting in line, the others.
Your Lordship, that is different thing. My case, I am arguing that
All right.
2010 rule.
Where are the rules?
Lordship,
Do you have an extra set of the rules?
it is in the body of appeal memo itself.
Appeal memo.
Yes. We have filed affidavit along with the affidavit rule is. Yeah.
You have annexed the rules.
Yes, yes.
At
While
annexure,
annexing, while
what is the annexure number?
That my lord will find that memo of appeal at page 121. In the memo of appeal. That were a part of his pleadings, my lord, before the honorable single judge,
121.
my lord, in the memo of appeal.
Yes, just hold on. Even the judgments have been annexed. What is this? Yes,
page 126 is the relevant page, Lord.
right.
Rule 13(1)(a). So sub
126.
registrar appointed on commission basis.
Hmm. Right.
So
So this is a fresh appointment, not a regularization. This rule provides for. Anything in the rules regarding pensionable service?
rule, under old rules, it is 10 years. So
Gentlemen, under these rules,
under
what is the provision for pension? If the rules say that the new pension scheme will be applicable even to those who are appointed under section 13, clause 13, then you will have to challenge the validity of the rules.
there is no such clause. I have gone through it. There is no such bar. It will follow the state government. That is there only. Relaxation clause is there, but no such bar. Relaxation clause plus 25. But there is no bar of new pension rule. My lord, what I am to prove my substantive appointment, then I am eligible for Rule 31.
All right.
My lord,
Rule 31 of rules of 1969. What does that rule say again? Let's
Before that, Lordship,
Yes.
I will draw your Lordship attention to first round of litigation.
Mhm.
That is at page 39 of my affidavit in opposition.
Yes, read.
Yes. These judgment they have not challenged.
Now, what does that judgment say?
Lordship, kindly come to page 39. Annexure
The
7.
31, gentlemen, 31, how would it apply to you? Read thirdly.
Lordship,
31, thirdly. Rule 31.
oh. Third rule,
31 clause third. Thirdly. Read.
rule 31 of 1969 rule.
Yes, read.
Yes.
How do you get out of clause thirdly?
In individual cases subject to such condition as.
The service of an officer does not qualify for pension.
Yes.
Clause-
Services rendered by an officer to count for pension. For rule, invocation of.
31 clause thirdly.
Clause third,
The service must be paid by the government.
yes.
Yes.
Must be paid,
So the government was not
paid-
paying for your service.
paid that salary basis and commission basis. Lordship, whether it is same or not,
Mm.
that then I will have to take help of that Supreme Court judgment.
Okay. Now, what you were saying from the earlier round of litigation, point
Yes,
it out.
yes, yes.
Yes, come to that.
Annexure 7, page 39 onward.
Mm.
This is the judgment they have not challenged.
Read,
That's-
how does it help you?
Yes, because it gave certain direction to the government, and government passed the impugned order without considering this judgment.
You are reading at page
39 of my affidavit in opposition,
Page
Filed in the-
37, judgment is at page 37.
page,
Right.
Page 39.
Right. What do you want to read out of that judgment, please?
I will read
Mm.
from para 9, page 41.
Mhm.
Lordship. Before that.
1910-2012.
Yes, yes, yes.
Yes, para 9. Read,
Yes, para
please.
9. In Chandra Prakash Pandey, the
Yes.
apex court held that core companies working in cooperative society towards realization of outstanding dues on commission basis are holders of civil courts. It has also been held that
The-
the said amines are entitled to.
That is the judgment of the Supreme Court in the earlier judgment.
Yes.
And that judgment you cited, Kurkamin. Kurkamin. But-
Kurkamin judgment, I have already submitted the.
Yes.
It is in the case record.
What do you want to point out from this judgment? What is favorable to you,
They are-
which as per you concludes the controversy?
The question as to when a person, in this connection, it has been observed as from Kurkamin's judgment, it has been quoted. That is a judgment of, that judgment is given in relation to a 1967 Supreme Court by constitutional bench, Kanak Chandra Datta versus State of Assam, where in Assam Valley, Mojadars were paid commission, not salary. That was the issue before the constitutional
See,
bench.
sir, you are relying upon the judgment of 1910-2012. That judgment doesn't decide anything. Read para 30, para 14.
This judgment, earlier litigation directed, first some direct,
Sir, please read para 14 of that judgment.
para 14.
Yes. There is no conclusion as such. That is the problem.
Yes, yes, yes. But para 15, in para 15, after 14 and 15, I will read. Lordship. In the instant case, the petitioner was appointed when there was necessity of sub-register in a
Yes.
particular operational area. He rendered his service to the government, and in lieu thereof, he was paid commission. While he was continuing as such, his service was regularized with effect from 25/4/2008. Now, in view of this, his regularization of service with effect from the said that till his superannuation on 28/2/2013 will fall short of the required length of service and or qualifying service for pension.
Mm.
That is the whole issue of it. Hence, it is the strength of the respondent that he is not entitled to monthly pension. However, Rule
Right.
31 of the.
Now only rule 31 has been quoted. Whether that rule will apply to the petitioner, that has not been decided.
That has been decided in the impugned judgment. Lordship.
Let's see. Yes.
Yes.
Yes, yes, yes. Okay. Let's see.
The government was.
That,
so
of
ordered.
course, that judgment is under challenge.
That judgment.
Yes, yes.
Now, the direction was passed. Those directions were not followed. They did not prefer any appeal against this judgment.
What
19
direction was
19
passed? The direction was to pass a speaking order. They
Yes,
passed the speaking order.
yes.
Yes, they could understand the things.
Now, my lord will come, how
What is the
the-
stand of the finance department?
at the time
Just
of,
hold on, sir. What was the stand of finance department in that writ petition, which is referred to in para 15?
finance department passed that order, that
Ah.
affidavit. That
Okay,
is in the appeal.
okay,
My case is to be considered under FR 22.
all right, okay.
Lordship, in the
Yes.
impugned judgment
Hmm. Read.
from para 31, in my affidavit, it is page number 59
Hmm.
of that, of the impugned judgment.
Yes.
From
It has
an
been,
analysis of the nature of appointment,
yes.
and before that, one similar case in Dolipur Bazaar, para 30 I will refer.
Hmm.
That judgment we have got, copy we have got, that will help us a lot.
Which judgment?
Dolly Pujari.
Yes,
It is a division based.
what has been held in that
by my
judgment?
lord, the ticket Roy, that Dolly Pujari judgment.
Yes,
I have already submitted.
you have already given the judgments, yes.
Yes.
Page 40,
2000.
page 43. Yes,
This is Dolly Pujari is page 43. Yes. It is in the bunch of judgment, page 43.
Mm,
This judgment has not been challenged before the apex court. It has
okay,
attended finally.
very well.
So Rule 31, apart from my Lord Justice Amita Roy also passed one judgment.
Sir, this court passed the judgments.
Lordship,
You need not identify the
Lordship, sorry.
judgment
So-
by the name of honorable judge. Yes,
So these judgment says regarding
continuity in
post.
service. Yes,
substantive post.
substantive post, all right.
Yes.
Okay.
Now, so what is a substantive post? If I am for a longer time, government did not regularize my service. That is in Baleswar versus cases. Lordship, I have again annexed it. Yes. Yes. Yes, it is there. It is there. I did not retire on commission. I retired on salary after
Yes.
entering 4 years, 9 months.
Aleshwar Das, what has been held in that?
Yes, Lordship.
Mm.
Yes.
That was an appointment in consultation with the commission. So that is this distinguishing feature of that case.
Concept of substantive post, Lordship. Page 16, straightway.
Sir, temporary post under the rules. There were no rules earlier. So how does this judgment apply to you? This judgment
In
doesn't
my
apply.
case also, there was no rule earlier.
So in this case, there were rules. The appointment was under the rules. It was with the consultation of the commission. There are 10 different features by which we can distinguish this judgment.
Dolly Pujari judgment also, my lord.
Dolly Pujari, you have said, you have
Yes,
already
Dolly-
referred
Dolly
bills.
Pujari also. What is the substantive post? It has been clearly stated.
All right.
Lordship,
Yes, Dolly Pujari, read.
it is page 43 onward.
Yeah, right.
Yes.
Mm.
Head note, Assam Service, says pension rules 1969 rule 23 of 31, 33. Superannuation pension. Pensionable service.
This is closer to what you are arguing because the post was then incorporated as an encadred post by the department subsequently. So
Yes.
this is closer to your case. All right.
Yes, yes.
Okay.
So,
So,
I was working in a substantive post
all right.
for 24 years, 9 months, some days. So, what earlier landed single was directed, whether my case is covered by Rule 31.
Earlier, the learned single judge gave them absolute discretion to pass an order. They passed an order as they could
But
understand it.
no discussion about what is the finding.
Yes.
Total departure without filing an appeal.
What departure? The learned single judge said that consider it, pass the reasoned order. They passed the reasoned order.
All right.
You should be thankful for them that.
Impugn order survives.
All
The
right.
impugn order discusses this Dolly
Very well.
Pujari judgment also.
That is for us to decide.
Yes.
Okay. Anything else to be said? This is
And regarding that non-applicability of clause 4, yes, that
clause 4 of what?
that 1969 rule. Yes. That dispute, Learned Singular clearly discussed it.
Mm.
Kindly have a look at yes, page 54 of my affidavit in opposition
Mm.
of the judgment. Para 21.
Yes.
of the imperial judgment, Lordship.
Mm.
May I read, Lordship?
Mhm.
Issue is not of retrospective regularization of the service of the petitioner. Question for consideration is whether the service rendered by the petitioner as sub-registrar on commission basis should be counted while completing his pensionable service. In the order dated 5/12/2011, the stand taken by the government was that since the petitioner received commission remuneration by way of commission and not by way of salary, he would not be entitled for pension in view of the provisions contained in Note 2, Roman 4A below Rule 44 of the Assam Services Pension Rule 1969.
Right.
Provisions of Assam Registration Service Rule 2010, which provides for counting of such service rendered on commission basis under Rule 13A, would not be applicable in the case of the petitioner as he was regularized on a prior date, with effect from 25/4/2008. Whereas the Assam Registration Service Rule 2010 came into
force in 2010.
Said
Yes.
rules are prospective and cannot be applied retrospectively.
Okay. Right.
In the second order dated 4/5/2013, there's the impugned order, Lordship, which has been impugned in the present proceeding.
Mm.
The stand taken is that the service of the petitioner was regularized with effect from 28/4/2008. This case would not fall within the purview of Assam Services Pension Rule 1969. It is a small typographical mistake, 61. As the post created after
Right.
1/2/2005.
The discussion is in para 24 and para 25. That is the discussion wherein the substantive nature of your job
Yes.
is discussed.
Lordship.
Yes. All right.
The para 23 has already discussed above.
Right.
The core issue which arises for consideration in this proceeding.
All right. We'll consider. We'll read the entire judgment. You want to say anything?
Yes, madam.
Right.
So my humble prayer is to dismiss the appeal.
Yes.
It has gone against the settled position of law.
Okay. Yes.
Apart from Kur Committee's judgment that Dolly Pujari and some other judgment also I have an
We'll consider. Yes.
appeal.
My respectful,
Yes.
For
All right, sir. You have said it thrice. Thank you. Yes.
my respectful reply will be, my lord, that initial appointment, it was a stopgap arrangement. It was not a regular.
Were you having any other service rules in force whereby you could appoint registrars or sub-registrars?
No,
Were you having any mechanism in place?
no, at that point of time.
Then you just extract service from people, don't pay them, just leave them at the mercy of commission.
No,
Then you say that, no, that was not a service.
no, that,
So then all registrations which they did during that period, they should be treated as annulled or what?
yes, in the appointment letter, he was given a liberty, my lord, to compete in, my lord, competitive examination.
All right, so you should not have,
Selected.
you should not have regularized them. Why did you regularize their services?
No,
If he was not competent, he has been performing the post for good 24 years. Why did you regularize the services? He did not come in litigation. Why that benevolence was shown by you?
It was regularized, my lord, since he was already in service, my lord.
So you found him to be competent.
Competent, my lord, but the regularization order itself says, my lord, that it will be prospective, my lord. It will be prospective, and in the appointment letter, my lord, 1984.
So for prospectivity was only to the extent of giving him salary,
Yes.
nothing beyond that.
The salary-
Prospective meaning thereby that after the order he would not get commission.
Yes. he will not
So
get commission.
he got into an encadred post.
Yes,
You did not have a post which was encadred before that.
my lord, Lordship will kindly, my lord, appreciate, he is getting all the service benefits, save and accept, my lord, the pension.
Yes.
He is getting pension. It is not that he is denied of pension.
He is getting pension under the NPS.
NPS. Now
Yes.
he wants to lay
So-
claim before, my lord, before this.
Yes.
That 1969.
Yes,
rules are
yes.
Applicable. Now 1969 rules, my lord. is-
All other states are going for the OPS, Mr. Council. Old pension scheme. All states are reverting back. Why? NPS serve the purpose. Why do you need a new pension, old pension scheme?
I need not comment on it, my lord. I do not
Okay.
carry the jurisdiction to comment on it.
Very well.
My lord, one decision, my lord, I will be relying, my lord.
Read.
Yes, 2002 10 SCC 674.
Have you given the citation?
Yes, yes, my lord.
Yes. 2010.
2002 10 SCC 674. paragraph 2. This is, my lord, state of Punjab versus Ishar Singh.
Mm,
Paragraph 2.
yes.
Now, my lord, his appointment, the writ petitioner's appointment was not a regular appointment. Way back in the year 1984. He came to be regularized only, my lord, in the year 2008. Now, this judgment says, my lord, that the past services cannot be counted.
All right.
The respondents were, my lord, I'm reading that particular paragraph 2, my lord.
Mm,
The respondents were initially appointed as horticulture inspector on ad hoc basis without following due procedural law laid down
yes.
in the recruitment rules. Subsequently, their services were regularized and orders appointing them on regular substantive basis were
This
issued.
case, this judgment doesn't indicate that there were no service rules in force. It's a peculiar case at hand. There were no service rules at that time when you use their services.
Yes,
You are referring to two facts, Mr. Counsel,
my lord.
that there were recruitments in the intervening period.
Yes.
Under what set of rules? There were no rules. How recruitments were called for? Tell us. Hmm?
To that extent, my lord, pleadings are silent.
Okay, very well. Arguments are judgment, sir.
My lord.
Yes.
Item 18.
May I please, as your lordship?
Yes.
My lordship was pleased to hear this matter on 23/3/23, my lord.
Mhm.
And there is an observation has been made, my lord, that we made a proposal for the amicable settlement, my lord.
Right.
And my learned senior friend, my lord, was required to respond to that proposal, my lord, today, my lord. So, my lord,
I have, my lord, discussed the matter, my lord, she came, my lord. In fact, she said that it is, my lord, taking into view the property is having and the income. My lord, he is offering a very meager amount of 65 lakh.
Okay.
And my lord, she is not agreeing to that. She says that she is expecting that a amount of rupees 5 crore, my lord. My lord, as I am saying, now, my lord will decide in between something can be done, my lord, whether they can, my lord.
No, we don't recollect. This is arising out
My
of
lord, that nikah.
nikah. All right.
Talaq.
Okay.
Your lordship has passed an order on that.
my lord.
So she is not agreeable to this proposal.
65 lakhs, she says that is a very small amount, my lord. Since 2009, she was ousted from the home. And
All right, so then argue on merits. That's the only way out.
My lord.
They are not ready to that
If the
proposal.
Next, my lord, sitting, my lord, matter be fixed, my lord. And my lord, if they can raise to something, my lord, or my lord,
The
can sit
offer
to-
can be improved upon.
They can sit together, my lord, also, my lord.
No,
All
my
right.
lord, we are not, we are not. in a
Or the
position,
matter may be sent to mediation. So, my lord, that can be.
You want that, sir? The matter to be sent to mediation?
That will be better, my lord.
my lord, we have discussed with our client, my lord, he is not also agreeing and he has already offered 55 lakhs, my lord. Kindly consider, my lord, but they, as the parties are not agreeable, my lord may hear the matter on.
All right. The proposal given by the respondent, hurdle and counsel for the parties, the proposal offer given by the respondent,
Appellant.
appellant on the previous date of hearing has not found favor with the respondent as is stated by our counsel, Mr. Agarwal.
Mal.
Thus, list the appeal for hearing after 2 weeks.
My lord,
18th of May, can it be, my lord? 18th of May, they are.
18th May.
Mal. Oblige.
Right.
33.
Supplementary.
My lord, these
Yes.
appeals, 3 appeals are, my lord, against the common judgment regarding, my lord, construction of roads under the PMGY scheme. Today, my lord, I will not take your lordship's time because, my lord, I have got an interim prayer. But
Okay.
before considering that, I implore that your lordship will ask the, my lord, the council for the PWD to obtain instruction what progress they have made pursuant to the direction of the honorable single judge. Because
Yes.
My lord, I am for the respondent number 1, my lord. I am the original petitioner, my lord.
Okay.
My lord, in fact, my lord, I have collected.
Respondent number 1 is the state of Assam, PWD. Who is there for PWD?
PWD.
Public Works Department.
The direction was that, my lord, there has to be a measurement of the work that we have done, and the rest of the work has to be given to him. That has to be carried out within a period of 30 days. And we are
All right.
arranging that.
Call the peer review council, sir. Maybe we can ask them now. Because this appeal, before us, it has come up first time.
My lord. Then your lordship may issue notice on the interim period also. my
All right, issue notice. Heard, issue notice of the appeal as well as the prayer for interim relief, IA number so and so, to the respondents. Mr. So and so appears for the respondent number 1. Thus, steps for service on the remaining respondents be taken within 3 days.
My lord.
Thus, the service is permitted. 6 and 7 mark is attendance. All right.
All right.
Rule is made returnable in 3 weeks. Okay.
They are also official respondents. They can also respond. Well. They are official respondents. Anyway, law obliged.
Okay.
34.
34.
34, 35,
Yes,
my lord,
they are all
the
same.
my lord.
All same. Till 35, they are all same. Hmm. Hearing matters.
Item 3 to 15.
Please, your lordship, as per the last order, your lordship, I was supposed to prepare a brief note.
Yes.
So I've already provided
Let's
the bench section,
Let's see.
and I have shared the copy with the AG. Now, what I have done in the note is that I have compartmentalized it into 3 aspects: the FIR, the framing of the charges with the charge head respective,
And the evidence.
and your lordship kindly come to page 8.
8 of your
Page-
note.
Yes.
All right. Yes.
Sorry, my lord, page 6.
6.
6. Serial number 3, your lordship.
Mhm.
This part deals with the conviction sentences passed by the learned special court along with the evidence relied upon by the learned special court for coming to the findings for conviction.
Hmm.
Now, your lordship, I have made it A1C Pojenda Hojai with the corresponding criminal appeal number and the
Right.
para 2261. That was the evidences which the learned trial court special just looked into.
Mm.
And your lordship will find that PW 29, the rate, those were the hostile witnesses.
Mhm.
And your lordship, my findings,
You made them in 9 in
Yes.
red color.
red color,
You highlighted them in red color.
red
Yes.
color.
Yes.
And at page 13, your lordship,
Mm.
page 13,
Right.
that is your lordship, in the impugned judgment, the
Mm.
findings are from page 214 to 2141 to 2194.
2194. Right.
Your lordship, there are 3 sets of convictions were there.
Mm.
Bearing accused Niranjan Hujai and Joel Carlosa and Vanlan Chana, all were convicted under 120B and 17 and 18.
Mm.
As far as Mohit Hujai, he was convicted for life. As per Joel and Niranjan Hujai, they were convicted for life.
Mm.
Others, 10 years is the maximum.
10 years. Okay. All right. Now, who is to start the arguments? Probably
Let my seniors.
Mishra Sahab will start the arguments. Ms. Chaudhary, you are having the summary?
Yes, yes.
All right. So you are ready to satisfy the court how the evidence of hostile witness is to be treated?
Yes.
All right. Okay. Hmm.
People यहाँ निकाल के दे रखना चाहिए ना। Wait, sir. My lord, can you have FIR, volume 1 paper book?
Volume 1.
Paper book.
Then you'll have to keep someone with the volumes. And make it some space in the books. Paper books, bring them here, yes. Yes. Madam. FIR, yes.
My lord, page number 1, if you lordship will see, this is in the format. And the
Volume 1,
volume
FIR would start at page number
1, the format. It's on format.
1, right?
Yes. Then your lordship will come to 3. Page 3.
Mhm.
I'll place it. for you. The officer in charge, Basista Police Station. With reference to above, I beg to report that on the basis of a specific source information
Mike.
today on 1/4, your lordship didn't get
Whereas the central government has received information. You are reading from page number?
I'm reading from page number 3. Page number 3 of paper book 1. There are 2 sets of paper. One is exhibit, other is paper book. Exhibit.
Part 2, part 1. No, this, we are having the FIR. NIA number 1/9. One wala dena file. But this is it, FIR is there. Please read, where are you reading from? Column number?
Page number 1.
I beg to report. You are reading from there?
No, this is format under 154. This is format under 154.
Volume 1, part.
I think are we having different people?
NIA number 2/9 or 1/9?
No, 1. We are concerned with 1.
1. So presently we are having all these appeals. All these appeals arise from NIA number 1/9. So why this paper book of 2 is here? There's a separate appeal.
It was clubbed in.
Have been clubbed.
1 and 2 was clubbed in.
But what has happened to those appeals? NIA number 2?
Together it's going on. It's going on together analogously.
They are listed today. Items numbers?
Well, the case has been merged in, my lord, with this.
Merged means what?
It was merged in 1 and 2. 9. Item 9 and 15.
9 and 15, they are NIA number 2.
Yes, ma'am. That is for NI 2.
How this merger, why we don't understand? It's not a joinder of charges that we can hear the appeals together.
Rates are arising out of NI 1, my lord. NIA 1.
That's what we are saying, that why this confusion? Item number 15 is also out of 2.
Yes, my lord.
Because
15 and 9, 2.
which is the order whereby these files were merged? Any particular date?
Date, do you remember?
Because we'll have to then detach the
Yes,
files.
yes, absolutely.
There has to be an order, otherwise they'll all be considered as heard together.
So if your lordship give me some time, I can check it. with
You
my-
please have a look at the order and
Lower
let us
court-
know.
Lower court order.
Yeah, we'll pass that order right now and we'll continue the hearing even right now. All right, sir, please carry on. In the meantime, please search for that order and let us know. Yes, with reference to the above.
With reference to the above, I beg to report that on the basis of a specific source information today on 1/4/2009, around 4 PM vehicle intercepted at 14th mile BS Road. And on search of the vehicle, the following persons suspected to be the cadre and linkman of DSPJ organization were found occupying the vehicle. And from their position, arms of some of rupees 1 crore.
DHD means stands for?
Diba Halan Dauba.
Okay.
It's in Dimasa language and they are predominantly in Haflong district.
Okay.
Crore meant for purchasing sophisticated arms and ammunition to wage war against the state, as well as to carry their nefarious and illegal activities along with 2 pistols, other documents, including letterhead so of DJTJ, were recovered and which were seized accordingly. This was lodged by PW10, Majuddin Ahmad. Now, but pursuant to this FIR, the 2 persons, accused number 1 and 2 were arrested on the spot. And
Fojendra Jai and Babul Kemprai. Right.
and Fojinder Hojai. They were arrested on first only and they were released also on bail, but they were kept calling. Now, the appellant before your lordship, Mohit Hojai, he is accused number 3.
Okay.
He was arrested on 30th of May, 2009. 30th of May.
Do we have a list of dates anywhere convenient?
It's of course I have a.
Get it prepared during the course of hearing. Please get it prepared and.
Yes. By tomorrow, if your lordship continues. From
No,
2
we'll
o'clock,
continue, of
then,
course.
then I'll make a list
Yes.
of it. Otherwise, I have ready today what I'm going to argue before your lordship.
Please continue, please continue.
Now, my lord, the Ministry of Home, by their order dated 1/6/2009, that your lordship will get in Exhibit P, paper book 8. Exhibit paper book 8.
Paper book 8.
Exhibit paper book.
So this judgment file, we can, for the present, leave it
For the
aside.
present, yes, my lord. And in fact, in your,
Make a space here.
my lord, in fact, the judgment, that's why I have noted the internal page. It's there in the appeal memo and your lordship do not have to lift one of those big volumes.
Yes. Right.
Your lordship will kindly come to page 1739. This is the order by which the matter was referred to or transferred to the NIA.
NIA 1739.
Whereas central government has received information about the commission of offence under 120B, 121, 121A of the Indian Penal Code and under section 25(1)B of the Arms Act 1959 in respect of which crime number 170 of 2009. This is the FIR. Basista Police Station on and C/209 at Jungmukh Police Station in the state of Assam.
3 would be
2.
okay.
And whereas the central government having regard to the gravity of the said offences and other materials in its presence is of the opinion that the said offences, scheduled offences under the National Investigating Agency Act 2008 and offences connected to the scheduled offences under section 8 of the said act affecting the security of the state and hence he should be investigated by National Investigating Agency. Now, therefore, an exercise of power conferred under section 5 of section
NIA
6
Act.
of section 8
Yes, carry
it
on.
has been referred.
Hmm.
So, the central government hereby suo motu direct the National Investigating Agency to take up the investigation of the aforesaid case and such other offences as may come to light.
No, we
during
need
the
the old act. Need the old act. Yes. Okay.
Now, the
Yes,
lordship,
please carry
would
on.
like to have NIA Act.
Yes, we'd like to have it handy.
I can give.
Old act last time it was there.
It will look.
There's enough. Old act Bengali library se manga lijiye. Get it from library. Yes.
What time?
Yes, please carry on. Get it
Lordship,
from library.
2 sections have been mentioned, subsection 5 of section 6, that's power of the ministry, my lord, the government of India to refer the matter.
And schedule offences.
My lord, no, that is section 8.
Section
Schedule
8.
offences are section 8
Right.
and section 6, subsection 5 This order is passed by the government of India, referring the matter to NIA.
Right.
Now thereafter, my lord, in exhibit 8 only at page 1737, if my lord will kindly do.
37. Yes.
Your lordship will see they also have registered an FIR,
Okay.
but it is this FIR only basically, but there's
Yes.
nothing here. These are the FIR, my lord, I need not specify a lot. Your lordship got 1737.
37.
Yes, this is the
But
FIR.
there are no contents as
No,
such
because contents are the earlier.
original. So
Because
this is basically they have renumbered the FIR.
But basically
Yes.
that is the exercise which they have done.
Yes.
In what CBI does, my lord, if it is referred, they will first register a FIR as preliminary.
Preliminary report,
Preliminary,
yes.
and thereafter this
Yes. RC,
Now-
they call it RC.
regular. Now, my lord, the NIA, after the investigation, submitted charge sheet. And your lordship may have volume number 9 of the paper book, not exhibit, paper book 9 at page 2199. Yeah, it was.
Two one.
2199.
2-1.
The fourth page.
Yes. This is the chart sheet.
Yes. My lord, this is dated 17/11/2009. And I'm representing my lord 1 and 3 both. I will first argue 3, then I'll go to 1. 1 will not take time, it will cover.
1.
Fajinder ho jaye, accused number.
Accused number 1.
Yes.
All right. Yes.
Now, if your lordship will come to page 2200,
Ji.
2200,
Yes.
this is Fajinder ho jaye. Below that occupation, your lordship will see
Contractor and member of DSDJ.
Member of DSDJ is not a
Occupation.
occupation.
They feel that it is an
Yeah,
occupation.
that's what they feel. Then my lord will come to
All time, full-time job.
yes, yes.
Yes.
Then your lordship will come to 2202.
Yes.
Well, this is Mohit ho jaye. And occupation, if your lordship will see,
Ex-CM, NCLs,
NCL.
council and member of
Chief
DSDJ.
executive member. He is the head of the council, autonomous council, which is constituted under sixth schedule. Here also member of DHD. So these two persons I'm representing. And the allegation is, my lord, the allegation is that there was a conspiracy. There was a conspiracy for waging war against the state. This is the basic, my lord, charge. And pursuant to that, they say, pursuant to this conspiracy, a number of acts have been given, well, contributed or alleged against the accused persons, my lord.
Right.
Now, if your lordship, I have made a I've made a small, what I'm going to argue before your lordship.
Yes, please.
I can give it to Mr. Chaudhary.
And while the hearing is continuing, please, we need a chart of say, custody certificate kind of thing. On what date particular accused.
It's mentioned in the chart.
It's already there?
I'm sorry.
Okay,
It's-
okay,
it's
very well.
there. Wait.
Yes.
Chart sheet.
No, we'll take it. You please carry on.
Yes.
Yes.
Now, my lord, what is alleged is, I have written, if your lordship will see from.
The elected CM was forced to resign.
Again.
Then
Then
this accused
he,
got substituted in his place
yes, but there
for
was
the purpose of getting the contracts.
getting contract.
Right.
Now, the second is, my lord, after assuming charge of the council, the accused number 3, he defalcated, made a lot of defalcation with other accused to generate money for
For the
DHD,
band organization.
for DHD,
Yes.
terrorist gang. Terrorist organization would have been different case. Because funding, I submitted on 2 occasions. Funding, type of funding are covered by the UAPA. The first is section 17, which says funding for terrorist act. And section 40 says raising fund for terrorist organization. And organization are those who have been listed in the schedule. So these are the only 2. But here, NIA, my lord, the UAP has been applied by the, my lord, they are the one who said, funding gang.
Terrorist gang. All right.
Now, my lord, terrorist gang as such is not an identifiable and permanent body. Terrorist gang would be few persons, an association of persons, and they do some
Indulge in a terrorist activity.
That is section 20. That being a member of the DHD gang, you indulge in terrorist
activity.
Now there is no terrorist act
As such, in this entire
thing, not
sequence,
a single
there's no terrorist act is
as,
alleged.
my lord explained under section 15. Not a single terrorist act has been referred.
UAPA Act. UAPA Act also. Yes.
I'll
No, we'll have it. We'll have it.
I think we had given, my lord, earlier NIA Act. It was in
NIA Act is here.
yes. No. With that
Photocopy.
UPAPA. UPAPA. Unlawful. Yes.
We have given 2013 edition because there are changes.
Changes thereafter. 2013, last time.
Yes, I
So
gave.
where are they?
No, pilot.
Pilot that
Print was given last day. Last day. Print. This will not serve the purpose. Is there now? Okay, right. 2 sets. So we'll first. So gang can't be identified with an association. Gang cannot.
Unless they act, they do some terrorist act.
All right.
Your lordship will see 2 sections 2M.
2M.
2L. L2L. Terrorist gang.
Gang, yes.
Means any association other than terrorist organization which systematically or otherwise which is concerned with or involved
in terrorist act. So as you say that there is not even a charge of a terrorist act.
The others are facing, but what I'm saying is not a single incident.
In NIA number 1/2009, is there any allegation of a terrorist act?
No.
Any culmination of the collection of money into a terrorist act?
That they are alleging. But they are alleging, but I'm making myself clear again. Normally what happens, a terrorist act is committed. That is subject matter after investigation, that will be subject matter of trial.
So section 15 charge is there.
Section 16, because section 15 explains what is terrorist act. Section 16
charge
says
in 16.
charge.
Punishment is in
16.
16.
Yes.
Right.
Now, whenever there is a charge,
so charge has to be combined of 15 read with 16.
Because explanation of terrorist
explanation of charge is there in 15.
and
yes.
16 says whoever commits a terrorist act will be punished on a scale which is there.
Right.
Now, I was trying to explain, my lord, that whenever a terrorist act is committed, it is investigated and the charge sheet is submitted, the court below decides whether the act, if somebody has died, whether that is because of terrorist act.
So A 1, 2, 3, what clause of the charge section 15 will apply?
Whether it will be covered by the explanation given under section 15.
Right.
And then, my lord, there would be, suppose a person has finance for committing a terrorist act, and the terrorist act he is charged. Now he cannot say that no, I did not finance for this. I had finance for different. So the law says section 17. It's section 17 of the act says that notwithstanding whether the that terrorist act is committed or not,
Committed or not. If the fund
Even-
is collected,
you are liable.
you are liable. Yes.
But the terrorist act has to be there. There, no, I cannot, my
No,
lord,
But
conceive.
the section 17 contemplates
Yes,
a terrorist act
yes.
in future. A sort of, it's a preparation basically, which is made an offense.
That's right.
Collecting fund for a terrorist act.
Yes.
Yes.
Now, 17, one more thing I'll point out. Whoever intentionally,
Mm.
by use of force,
17.
I'm sorry, and this is whoever in India
Mm.
or in a foreign country,
Right.
directly or indirectly, raises or collect fund
Mm.
and provides fund to any person
Mm.
or person, or attempt to provide funds to any person or person, knowing that such person, such funds are likely to be used by such person or person to commit a terrorist act. Now, your lordship, the next line is, notwithstanding whether
Such fund is actually
fund
used or not.
for commission of the
Right.
act.
So commission of act is not relevant. Only collection of the fund and the purpose for which they were collected.
That, my lord, one more thing I will say,
Mhm.
the very word such, whether
Such funds.
fund is used for committing such terrorist act.
Such
such
funds.
act.
Such funds.
Yes, my lord.
So the knowledge, if we break up the section,
Yes,
the collection of funds
yes,
or provision of funds to any person, knowing knowledge is there that such funds may be used for a
Yes.
terrorist act.
yes,
That is the crux of the section.
yes. But what I am submitting, I will submit, my lord, when I go to 17, because that will be a question of law, pure. The very use of such act,
Mm.
my lord, it envisages or signifies presence of a terrorist act in trial. Mere, my lord, funding without.
Plain language is even in contemplation. Even in
Yes.
contemplation that it may be
No, because
used,
money will,
act may be used, the act may have been committed or not.
money will have to be provided first before any terrorist act is undertaken.
Obviously.
So it will come first.
Mm.
But a person can be charged if it is shown that there is a terrorist act and he may likely, he knew it and he has provided fund for it. Or at any rate, he knew that this is going to happen.
Mm. All right.
Now here,
So some kind of remote connection with the terrorist act is necessary.
it has necessary, my lord.
That nexus has to be there.
For TADA or for UAP, my lord, till 2004, it had actually no teeth.
Mm.
The maximum sentence was 7 years.
Mm.
And
Yes.
I have a 2001 edition of
Mhm.
this, my lord, unlawful activity act.
Mm.
There was absolutely nothing here. In 2004, all the provisions of section 3 of TADA
Tada were
incorporated.
Yes.
So therefore, my lord, commission of a terrorist act
Mm.
has to be a subject matter of the trial. Otherwise,
Mere
Lord,
collection of
it-
funds is not relevant. Even if there is a collection of fund, they will have to prove the nexus with a possible terrorist act.
possible, my lord, what I'm saying is
Mm.
the word knowing fully well that such person, now such person could be anybody.
Mm.
It could be a terrorist gang, it could be
Right.
a terrorist organization, or it could be a simple lone terrorist. So, therefore, my lord, funding will have to be with knowledge that these people are going to indulge in terrorism. That apprehension would come if the person to whom is having some
nexus.
some nexus with some terrorist, or he's a convict,
Mm.
or he's facing charges,
All right.
and there is allegation that he has committed so and so.
Okay. Mm.
So I'll go in detail, my lord.
Oh,
but
of course.
First of all,
It's a preliminary kind of discussion.
yes.
Yes.
So, my lord, the second one,
Mm.
Now, second is after assuming charge of the council, large scale money was siphoned off.
You're reading again at the chart sheet?
No, I'm reading the notes that I've given because this will show what I'm going to place before your lot.
Right.
So the first is, in fact, first I've already argued that day, if you're active, I'll just refresh.
Right, right.
Then the second is after assuming there were large scale defalcation to collect so that we have money. This is allegation. Now, if my lord will kindly take the chart sheet at volume 9, my lord.
Yeah, we are having the chart sheet. with us.
Volume 9, yes.
Chart sheet is there in hand. Yes.
Now, the page number which I'm referring, my lord, is 2232. 2232.
Yes.
The last paragraph. Since the involvement of public servant in NC Hill, my lord, this NC Hills was earlier North Kashar Hill. Now NC Hills is known as Dima Hasao district.
Dima Hasao district.
But using NC Hills we'll use because all through NC Hills and that time perhaps Dima Hasao was not, the name was not changed.
Right.
Since involvement of the public servant in NC Hills for misappropriation of government funds and their criminal misconduct forgery have been revealed, the matter is being referred to central government for investigation by CBI after obtaining necessary consent from the state of Assam or investigation by anti-corruption branch. So the defalcation has been given to CBI.
Were there any follow-up FIRs?
No, they had, my lord, in fact, the appeal is pending.
All right. There were FIRs. There were
3 years,
convictions also.
2 to 3 years.
Okay.
At this stage, what I'm submitting before your lordship. After all, defalcation will not be a subject matter of the UAPA.
UAPA, obviously, yes.
So, for the while denying everything, I'm assuming, my lord, that funds are available, whether I have sold my house or it have collected money from somewhere or borrowed money, fund is there. So that is not an offense. If it is there, it will be for defalcation under PC Act. Here I am assuming that yes, we have fund. Therefore, because out of 150, most of the witnesses are relating to my lord, witnessed about the defalcation.
Defalcation.
With respect to defalcation, there's all witnesses. So, 2, I will not take argument before lordship. 2 is in my lord, the point that I'm arguing before lordship, given a small short.
The siphoning of money, right?
So, because this is subject matter of another
different appeal, yes.
Now, third is accused number 3, Mohit Hojai, sent large sum of money to Calcutta through PW 535-106 and 21. None of these have supported. So I'll be submitting on that. Then I've written, the trial court treated Exhibit 97, that is the statement under 164.5. As substantive evidence.
Okay.
And conclusion in paragraph 109 and 343 of the judgment are contrary to the evidence on the court. So only on this point only I will submit this. Then next is money sent to Calcutta by accused number 3 were received by accused number 12, 13 and 14. There is no evidence of it. Then fifth is, my lord, accused 12, 13 and 14 after receipt of large sum of money in Calcutta, handed over the same to accused number 1.
From whom the weapon and the cash was recovered.
Yes. Those weapons are licensed weapons. He has not been convicted under 25. He has a licensed pistol. They said 2 pistols we have recovered. He had a licensed pistol. Now, 6th is Malsa Kimi, accused number 9, collected money from Fojinder Hojai, accused number 1, in the company of accused number 10. Now, my lord, there is no evidence to show that accused number 9 collected money from accused number 1.
Okay.
In order to create evidence,
they got approval.
He was made accused number 10 was honorable, and he was made approval, and he has given his statement as PW 29. Before that, I'll be placing. Then, my lord, accused number 9 handed over money to accused number 10 for conversion of INR into US dollar. PW10 converted the money with help of one Tapan, who, though was arrested, was let off. My lord, Tapan is would have been a very important link in the entire transaction, the alleged transaction, because he is the person who has got converted, according to George, INR to dollar and crores of rupees.
Okay.
But he has not even been referred as cited as
Neither made an
or
accused nor
made
made a witness. Okay.
because my lord, when I submit this point, I will submit this case of it's my lord, it concerns national security. And there is complete violation of Foreign and Exchange Act 1999, section 10 and 13. I'll be placing you a lot. Now, thereafter, my lord, I'll go to the next point. Accused number 9, thereafter, Malswakini handed over dollar to accused 8. There is absolutely no evidence. Both these accused have denied in their 313 statement. There is no evidence whatsoever. Then, my lord, accused number 8, Vanlal Chana, allegedly procured arms and ammunition and delivered it to DHD. This is the whole case which they have made out. And my lord, this prosecution case, it's not mentioned at one place. So, my lord, I had taken help to trace out the prosecution case from para 12 to 17 of the judgment.
Okay.
But that's not in detail. And then charge sheet 16.2, 17.8 onwards, up to 17.31.
Okay.
So these are the 9 points which I'll be submitting. 8 is gone because siphoning of money I'm not doing. My lord, kindly have charge sheet.
Yes.
Paper book, my lord.
Yes,
9.
yes, we are having the charge sheet in hand. Yes.
2217. 2217, I'm reading second paragraph. Yes. During investigation, it was revealed that the seizure of used cash and arms was part of the larger conspiracy for waging war against the state by the above named accused person. In furtherance of the said criminal conspiracy hatched in November 2008. Somewhere, my lord, it is November 2008, somewhere it is January 2009. That I'll be pointing out. In furtherance of the said conspiracy hatched in November 2008 in Guwahati, North Kachar Hills district and other places, the elected executive member of North Kachar Hills Autonomous Council resigned from the position to make way for Mohit Hojai, accused number 3, to assume charge as new CEM. Subsequently, Mohit Hojai and other accused public servants, along with contractors, committed criminal misconduct and defalcated huge sum of money from fund available with the Autonomous Council, Autonomous Council, which was channelized through Hawala operator to Guwahati to Calcutta to reach arms smugglers. They are saying arms smugglers, but eight is said to be the alleged to be the arms smuggler, who smuggled the arms and ammunition and supplied to DHD for them to commit acts of terror and violence and wage war.
Maybe halt you for a moment. As Chaudhary, there has to be a specific appointment of the arguing counsel on behalf of the respondent as a public prosecutor. Do you have that appointment? Do you have it in your appointment order to act as a public prosecutor?
That has been clarified by a subsequent. This issue came up in a different case. That has been clarified. I can place it before.
You please,
Yes.
please bring it, because we have our doubts in these cases.
That was
Because
taken up in another case.
CBI particular appointment is there for special public prosecutor in the High Court.
That is, Your Lordship, I have taken it up with the veteran, he's the regular PP.
Mhm.
Then they had issued a communication. I can place it.
Please keep that communication in hand. Yes, all right. Yes.
Now, my lord, so your lordship has seen, it gives a little picture, 16.2, the paragraphs which I have read.
Mhm.
Now, if your lordship has seen that the purpose of conspiracy, the aim and object of the conspiracy was to wage war against the state. Now, if my lord will kindly have for a moment Indian Penal Code.
Yes.
Section 121, madam.
Mhm.
Whoever wages war against the government of India, this was substituted, my lord, for Queen,
Mhm.
or
Yes.
attempts to wage such war or abate or waging of such war shall be punished with death or imprisonment for life and shall also be liable to fine. This is section 121, deals with waging war against the state. Now, 121A, if my lord will come to next week. Conspiracy to commit offenses under section 21, that is conspiracy to commit.
The offense of waging war.
Yeah.
Yes.
Whoever within or without India conspires to commit any of the offenses punishable with section 121. For the or conspires to overthrow by means of criminal force or source of criminal force, central government or any state shall be punished with imprisonment for life, which may with imprisonment for other descriptions which may extend to 10 years and shall also be liable to fine. So conspiracy to wage war against the country, there is a specific provision, section 21.
121 in the
21A.
121A, right.
Now, here, my lord, in this case, section 120B is used for to show conspiracy to wage war. 120B. Although there is a specific provision of 121A. But if my lord will just come to the judgment, your lordship take up your lordship's file, main file, where appeal is there. Then because your lordship has to go through. From there, I will tell the internal page and your lordship.
So we can leave the chart sheet aside for the time being?
My lord.
All right. Yes.
My lord may turn to page, paragraph 151.
And these are statements of judgment is there.
101, my lord, internal. 451.
101.
Sir, is the referring to?
451.
Para,
Paragraph 451, my lord, at page 2156, 281 of your lordship, the internal page. 281.
One. Yes.
The outcome of the above discussion and finding is that prosecution side has failed to bring home charges under 121 and 121A. So conspiracy to wage war is gone, acquitted. But 120B is brought for waging war. When there is a specific provision, my submission will be 120B will not be applicable.
Could not have been applied as per you. Right.
Especially when the allegation is I was conspiring to wage war against that I've acquitted.
So that if we go by that, there are two different parts. One is indulging in a terrorist act,
Yes,
and the second is waging war.
absolutely,
Distinct acts as per you.
absolutely.
So waging war charge has been
Acquitted, we have
caused-
been acquitted. no
has
problem.
been acquitted.
Yeah,
The
not
accused have
proved,
been acquitted.
Not proved.
Not proved. Yes. Okay.
Now, my lord, I'll take your lordships to the charges for a moment, my lord. If your lordship will take up paper book one, my lord, from where I place just the FIR. My lord, three separate charges have been framed.
Just to.
I placed FIR from there, my lord. Paper book, volume one.
Yes, paper book volume 1.
Yes. My lord, three separate charges are framed. In one charge, accused number 1, 2, 3, 5, 6, and 8, your lordship will find. And the other, at page 7, your lordship will find accused 12, 13, 14, and 15.
We will let you proceed as you like, but can we first read the charge sheet for a moment? That'll just make the entire event clear.
That will help me, my lord.
Yes. You can ask your associate. You can sit down, ask your associate to read.
My lord, so long I can.
Okay, very well, very well.
I have already placed my, I have placed, my lord, 16.2.
16.2 you have read,
I have
yes.
read. Now, if your lordship will go to 2220 at page 2220. FIR. Yes. Now, only a specific I will, my lord, otherwise there are so many things mentioned, may not be relevant. My lord, your lordship will come to 2229.
2229.
Paragraph 17.29.
Yes.
Channeling funds for DHDJ through Hawala at Kolkata. My lord God. The investigation at Kolkata revealed two aspects of the fund transfer. First, regarding channelizing of fund for DHD from Guwahati to Calcutta with the help of Jayanta Kumar Ghosh, A12, Devasis Bhattacharya, A13, and Sandeep Ghosh, A14, and Fojinder Hojai, A1, and second, regarding conversion of rupees thus received to dollar with the help of George Lanthang, accused number 10, and Malsa Kimi, accused number 9. The funds sent by Mohit Hojai, accused number 3, from Guwahati to DHD were sent with the help of one Imdad Ali through Hundi.
Imdad Ali
is PW35.
PW35.
From Imdad Ali, Imdad Ali, in bracket it is Hawala. The person involved in the parallel banking transactions apart from Imdad Ali was Hundi operator Ravi Agarwal. He is 106.
Okay.
And funds then received at Calcutta by accused Sandeep Ghosh, Devasis Bhattacharya, and Jayanto Kumar, 8, 12, 13, and 14. And then handed over to Fojinder Hojai, accused 1.
Accused 1.
Now, if your lordship will kindly come to 17.32.
All right. Vanlal Channa.
Yes, Vanlal Channa. I'll call him Vanlal for our convenience.
Yes.
My lord, 2231, the relevant portion I will read. On all the three occasions, 8 lines from the bottom, my lord, at page 2231.
Yes.
On all these three occasions, they collected money from the same person at Calcutta. Once it was Hotel Shalimar, twice it was Madhu Milan Guest House. All these disclosure corroborated a statement of Fojinder Hojai A1 is corroborating with 161 million. Jayanta Kumar Ghosh, Sandeep Ghosh, regarding exchange of money at Calcutta, which was sent by Mohit Hojai for Niranjan Hojai. Later, Fojinder Hojai was identified by A9 and A10 as the same persons from whom they collected money on behalf of Manlal Chana. So, my lord, the sequence as I have narrated, my lord, the first is there was a conspiracy to dislodge the Dipolal Hojai. That was first. Second act was take over as CEM. CEM is also elected, my lord. It's not like. So once accused number 3 became the CEM, he started defalcating money. Then he sent money to Calcutta through Hawala. In Calcutta, it was received by A12, A13 and A14. They handed over to A1. And then A1 was staying either two places, Salimar Hotel or Madhuvilan Guest House, from where accused number 9 came and collected the money, gave it to accused number 10. He got it converted with the help of one unknown person, Tapan. And then it was given back to A9.
10 is the
Approver.
Right. Okay.
And then, my lord, it was the dollars were given back by A10 to A9. Then A9 handed over to A1, who procured armament supply. And nothing has been proved, and that judgment itself will show.
Okay.
That nothing has been proved.
Okay.
So these are the basic charges which I have called out, your lordship will see from here.
Right.
So, my lord, I was taking your lordship through the charges. Paper book volume 1. Page 4.
Page
4. Charge under 120B.
Paper book volume 1. No, it's below this. Yes. Volume 8. Yes.
4. The first charge. All A1 is Fojinder Hojai, my lord.
Yes.
Then A3 is Mohit Hojai. A8, if you serial number 8, if your lordship will see, George Lanthang. And he pleaded not guilty. Who has been
Turned an approver.
approver.
Right. So he was charged basically.
Yes.
And
He
thereafter
was
he turned approver.
And thereafter, yes. And, well, Lord, he was in jail from 2019 till 2013.
9 to 13.
9 to 13. He was in jail and others were also there. And yet, some accused persons were made to identify each other in presence of an executive magistrate while in the police custody. Well, even A1 was on bail, but he was there. He was to report. He reported there. So I'll say to you that you, after forming terrorist gang, 120B, I need not take through all this, my lord. I just want to argue on the first line that is given. Because your lordship, I have shown in charge sheet, they are saying member of DHD, member of DHD. In each charge, your lordship will find you, after forming DHD or Black Widow in 2004. And particularly during January to March 2009, this is the other, I read it, my lord, your lordship has noted. The allegation in the charge sheet was 16.2 that conspiracy took place now November 2008. Here they are saying, listen.
January to March.
Yes.
Right.
Now, second one, your lordship will see, after forming the said terrorist gang in 2004, just one line. What is the basis on which I'm being charged that I have formed the DHT? Is there any evidence that I will show? But each charge is preceded by that sentence.
Terrorist gang.
You, after forming the terrorist gang. Now, my lord.
Second charge has not been found proved. Third charge has not been found proved.
Yes.
There's an acquittal.
Okay. And my lord, fourth, if your lordship will see, fourth charge. This is under section 16. You being member of Dima Halim Dawa, in short DHTJ, a terrorist gang, did terrorist act by killing 10 innocent drivers.
This is the terrorist act they are referring to. maybe,
subject matter of a different investigation and different trial.
maybe, yes, all right. So
Now,
there's
I
no.
will show from exhibit 272.
Mhm.
These are nothing, my lord, if somebody has killed. And if that case is referred, there will be postmortem report, there will be weapons, there will be witnesses.
So are these people, are these accused also arraigned in that case?
No.
No,
I will show my lord exhibit 272
we'll see. All right. Carry on.
because all these cases are mentioned there.
So, okay. So fourthly, again, is there a finding based on this charge?
17.
Fourthly, is there a finding in the impugned judgment on this charge?
Yes.
What does the trial judge say?
My lord, trial judge, so far as 16 is concerned, he says, yes, it is proved. I will take.
Not 16.
Ah.
Fourthly, charge fourthly. Pertinently charged fourthly, you say that is a subject matter of different trial.
Yes, 16, section 16. I will.
All right. This is a generalized kind of charge
Yes.
for 16. All right.
There is no specific charge.
Mm.
It will be clear, my lord, as I proceed with to
Carry on,
give
please.
the evidence.
Yes.
So, my lord, your lordship has seen at the beginning of each of the charges that have been framed, there is a sentence, a stipulation
Terrorist gang.
that you, after forming the terrorist gang, as if Mohit was
So the prefix of the charge is terrorist gang.
gang.
All right. Okay.
Now, I asked a question to myself, my lord, going through, is there any evidence to show that I formed, or is there any evidence to show who formed? Now, my lord, three witnesses, I will, my lord, rely, and I'll, first is, my lord, PW 46. PW 46 is at paper book, volume 2.
46. Yes.
My lord, kindly come to 378. Right?
Mm.
Your lordship got not 378.
378, 46.
Small in chief, I will refer, my lord. I had joined DHD in 1995. My lord, DHDJ was not even born. That is in 2004.
You must have cross-examined.
He was a cadre of DHD. Now, I will show, my lord, that a trial court has referred them as DHDJ.
J.
Yes, that's a. So I joined DHD in 1995. This is a militant organization led by so-and-so, who was chairman of the group. I remained with the organization from 95 to 2003. The militant organization was operating in Karbi Anglong and MC Hills, now Dima Hasao. The arms and ammunition required for the operation of the organization were purchased locally, and we also get it from Bangladesh. In 1995, I went to Bangladesh as I was directed by organization DHD. I remained in Bangladesh for 3 months. I went there, set up a base for organization, but could not set up the base because of the financial problem. So I returned. I do not know the source of Bangladesh, in which in the organization, chairman was so-and-so, vice chairman was so-and-so, CNC was so-and-so. Our militant camp was always on mobile, and cadres used to move. So the arms and ammunition were received at different places. He's talking of DHD. On January 1st, 2003, ceasefire was declared between the militant and the government. And around 300 cadres, including me, on signing of the ceasefire agreement, we shifted to designated camp. Well, what happens is, this part of the country,
There was a mass surrender, and then they are
then
sent to a
there
camp.
will be a camp, and the weapon will be kept separately. This is what is happening. So on 1st January 2000,
Similar activity happened in Chambal when the dacoits surrendered.
yes,
Almost similar. Yes.
that your lordship is talking of 60s.
Yes.
On January
No,
2003,
that still happens. The area is infested by dacoits. It's very difficult terrain. It's impossible for the police. So
Yes.
many a time they strike peace,
Yes.
some kind of terms, and then there are surrenders. Of course, now very sporadic, but they do happen. Yes. Yes, please carry on.
In October 2003, the organization were separated, and so went and formed another militant organization by the name of DSBJ.
Yes.
Your Lordship will kindly see 2003.
Mm.
This person is cadre of DSB, which were both combined, not separated. After surrender, it appears that DSBJ separated some person.
So basically, he wouldn't be able to say anything about DSDJ.
No.
Yes. Okay.
Then, my lord, he only says that he was attacked by a person named Daku Singh, who fired at him, and he received injury. That will be a separate case. I just 4 lines, and let me just complete.
Please.
In the year 2006, when I came to liaison officer Diwabari, Haflong, to meet Dilip Nunisa, and on my return to my camp at some so-and-so, on my way, I was attacked by Daku Singh, alias so-and-so, and another person to the group of DSPJ. On this attack, I received 6 bullet injury, AK-47 was badly injured, etc., etc. So that would be a subject matter of a different trial.
Okay.
So, my lord, he is a PW46 does not say that any other person who is before your lordship formed the group. It was formed by
Only
someone-
Joel
by-
Garlosa. Yes. What is the cross-examination from this witness?
PW46. I think 46.
Or probably Mr. Burgoyne will be referring to his statement.
Yes, my lord.
All right, we'll leave it for him. We'll leave it for him.
My lord.
Your argument is that he doesn't refer to anyone else than Joel Garlosa.
That is what he says. That is what he says.
Yes.
Now, my lord, I'll place 129, page 640, volume 3. 3 or 4 bit of you like that.
Page 6.
41, my lord. 40, but the relevant is 641.
Yes.
Your lordship will come to last paragraph at 641. It is correct. Well, they were declared hostile. The last paragraph at page 641. It is correct that there was communal clash between Hamar people and Dimasa people. It is correct that number of Dimasa people lost their life during that clash. It is correct that so-and-so separated himself from organization. It is known to everyone that after clash between so-and-so, Dimasa people, so-and-so formed the group called Black Widow. In 2004, there was a joint meeting with the Government of India, Government of Assam, and our organization. In that meeting, I was present. I remember that from government side, so-and-so were also present. I remember that so-and-so was not present in the meeting. It is a fact that I have stated before NIA. It is not a fact that so-and-so burned Dimasa village in so-and-so. So what I'm concerned at this moment, my lord, I'll go through these witnesses. At this stage, there is nothing in the statement which I just placed before your lordship that accused number 1 or 3 formed, or any other accused except me, the one whose name is there, formed the group, separate group. Then, my lord, the last witness on this point is 150, who is the Chief Investigating Officer, page 757, volume 4 of the paper book.
754.
757, my lord. He is Chief Investigating Officer, Mr. Mukesh Singh. My lord.
Yes, please.
My lord, page 758.
8.
Yes. My lord will have 11th line from the bottom of this first para towards middle. It was found, I myself recorded towards the middle, my lord. I myself recorded a statement of executive member of.
Yes.
Well, and others pertaining to the activity of DHDJ. It was found that Dima Halam Doga was formed after surrender of Dimasa National Security Force, DNSF, en masse in 1995 under the leadership of so-and-so. Pranab Nunisa was the commander-in-chief at that time. In the year 2003, DHD entered into a ceasefire agreement with the state, but so-and-so formed his own group called DHDJ with the help of other cadres. It was also found that one of the insurgent group, Hamar People Conference, abducted 23 members of Dimasa and later killed them, which included 17 of them whose family, who had family. As a result, Sri so-and-so also named his group as Black Widow. This was revealed from the statement of ex-DHD cadre, Philip Nunisa, 129.
Which you have referred.
46.
Yes.
So all these three witnesses whom I have produced, they clearly said, including the CIO, that accused number 1 and 3 never had any hand in the formation. And I said, my lord, accused number 1 is a contractor, first class contractor of the Northeast Autonomous Council.
Right.
And accused number 3 is a politician, my lord. He was elected in 1994. Then he was again elected, my lord, in between one election, of course, he was defeated. So in 2007, he was again elected. Therefore, my lord, the stipulation that your lordship has seen preceding the charges, the top of the charges that you
were the member of DHDJ.
After forming, there's no question of, there's no evidence on record. And that portion, my lord, with all respect, is not borne out by the evidence, witnesses who have been examined, or any other document. Now, having said this, I'll come to the first act which has been alleged, overthrowing the elected CEM, Deepo Lal Bajai. Now, my lord will remember, I referred to the paragraphs
From
of
the judgment. Yes.
156, 284, all that. And I have placed also that what was done is the witnesses who have been
Declared hostile.
IO was called and their whatever they have stated in the 161 was brought on record, and the
same was relied upon to affirm the charges.
Now that is, my lord, wholly incorrect, according to me, not admissible at all. Now, discussion by the court.
Yes.
My lord, that I'm not taking your lordships to the other, but paragraphs I can give you, lordship name.
We will, of course, yes.
Paragraph is on this point, overrowing. Paragraph 156 of the judgment.
Para 156.
156. Page 1985, internal 110. Internal 110. The evidence of 126 Dipolo reveals that in 2007 he contested election and won the same. After election, there was an alliance between BJP and ASDC member of both parties were elected as MSC. He was elected as CM on January 2008 till 26/11/2008. He was CM, but he submitted resignation and Mohit Hudai became CM. His evidence also revealed that this is other case, my lord, that Purnendu Langthasa, who was CM till June 2006, was killed by extremists. So we are not concerned with. We are only concerned that, my lord, resignation was not obtained by force, but he submitted. And even he has stated so in his
evidence.
Yes. Now your lordship will come to page, because, my lord, my problem is rather, I'm finding it very difficult. Something is here, positive, after holding negative. I will show, my lord. Then in, my lord, 471 paragraph, running into around 300 pages. I have tried my best, my lord, to cover everything, but I don't know if something is here and something is different in other paragraphs. Very difficult for me to see. Now 284, your lordship will see 2062. 2062, 187,
284. Para 284?
284, 187 of your lordships.
Yes.
Now, PW 20, he was also a minor cadre of DHD, not DHDJ. 2062, 187, if my lord, 187.
Yes, we are having it.
PW2 Rongsling Longthasa testified that he was a cadre of DHDJ NC Hills for about 16 years. From 1996, Niranjan Hojai was chairman, Dilip Nunisa was vice chairman, and so was commander-in-chief. On 1/1/2003, DHD groups entered into ceasefire with government after ceasefire. So continued with the organization and he suddenly disappeared. Dilip Nunisa continued with the organization and at this
This basically is extraction of the part which has been proved by the IO.
Yes. So all these, my lord, the same thing is mentioned in paragraph 285, then 287, 288, 289, 290, 291, and again, my lord, 442, 44.
So
Four
what,
and four.
what
All similar.
probably what defense would be arguing that the learned judge has not even referred to the re-examination part where the witness may have been confronted with this part. Straight off that relevant part of the statement which is proved by the IO
My lord.
that has been transcribed into the
Yes. So all these witnesses have been treated that way.
Right.
Now, my lord, that part of the judgment where these witnesses have been referred to or discussed, my lord will kindly come to page 292. Your lordship's judgment, it will be 194. 292.
Para 292,
Para 292, my lord.
That
At
is-
page 194.
194.
194.
Yes.
I'm placing. It would be appropriate, apposite to mention here that there would amount omission, there would amount to what would amount to omission and what would amount to your Lordship, to contradiction and how the contradiction has to
Has
be
to be
proved.
proved in the true import of section so and so.
So and so, so and
Yes.
so. Then he refers to Tahsildar Singh and V.K. Mishra's case. I have given these cases I have for your lordships.
We'll see the judgment still. You just
Yes.
carry
But
on with the argument.
these judgments do not support. There cannot be any judgment that 161 statement, you put it in the mouth of IO.
There is
recorded.
one judgment. We don't indulge in taking the names of honorable judges. Probably one judgment by Honorable Justice Gyansudha Mishra, wherein this kind of proposition has been mooted, that the 161 statement can be.
Yes. Yes, but that goes against 161, 62. It goes against, it can be
That's
only.
your argument. Mr. Chaudhary will have something else to say
Yeah.
about it.
Yes. So, my lord, then the next page, this is extensively quoted, V.K. Mishra.
This judgment, the trial court has quoted the judgment as such.
Yes.
Yes.
And then, my lord, will come to paragraph 292(1).
Yes.
In the
So
instance.
if you read from V.K. Mishra,
Yes, my lord.
read para 19, the attention of witness is drawn to that part, and this must reflect in his cross-examination by reproducing it.
Yes.
If the witness admits the part intended to be contradict him, it stands proved, and there is no need to further proof of contradiction. It will be read while appreciating the evidence.
There is
So
another-
that part
there
which is
your lordship
contradicted
just saying.
or which is confronted, that part has to be reproduced in the evidence of the witness. The IO is no one to prove that statement.
And my
So
lord,
you will have to satisfy the court from the statement of the witness. We put this part to the witness and he admitted it. If he admitted it, yes, we will read it. But if he says, no, I did not give such statement,
my
till
lord,
date, as the law of this country stands,
Yeah.
that will not be admitted. Yes.
in one of the judgment I was reading below, that if it is confronted and the accused and the witness says, yes, I have said, that's not the end. Everything is proved.
No,
The
no.
onus is still with them.
Still, that's right.
But yes, that part.
That part.
Yes.
That part, yes.
Now, paragraph 292 also deals with 161 statement.
Mm,
292 Hardan Vyas, this is West Bengal case,
mm.
is where.
Can be relied upon, yes.
Yes, my lord,
No legal bar.
those, whatever he says in the cross-examination, in chief, whatever comes out after the cross-examination.
Confrontation.
That can be taken.
That can be
There's
accepted.
no, but Hardan Das doesn't say that you record everything through IO, that yes, he has made this statement and so it is proved. Now,
Mm.
and then your lordship will see at page 413, 2136. Internal page will be
Para
413, my lord, 261.
413. Yes. Yes.
261. 413, this is very important paragraph.
Mm.
If we analyze series of events, past, contemporaneous, and after episode of 1/4/2009, that can be culled out from the facts and circumstances brought on record and proved by the prosecution witnesses. In chronological manner, we will find that Deepolal Hojai was elected as member of Autonomous Council and took over as chief executive member of NC Hills Council in January 2008. He continued till 26/11/2008, and he was asked to resign on 26/11/2008.
Yes.
In a meeting in the house in the evening, being failed to do, I don't know, wrongly, right, for the Masa people.
Too much
They
for
failed
the
to do anything.
do
perhaps,
much for the Adivasi people.
by accused Sri so-and-so, who was commander in chief.
Of
Deepolal
DH.
Hojai decided to resign in the meeting, and decision to elect Mohit was taken on
On the next day. Right.
It is to be mentioned here, the defalcation of fund meant for so-and-so with the help of government service. We are going on in the meantime. So defalcation is from previous
From
regime.
earlier regime.
Yes.
Yes.
This part of conspiracy took place in so-and-so.
Mm.
Now your lordship will see, there is not even a single witness. Even Deepolal Hojai himself, PW26 says, I resign on health ground. That part, my lord, I will just take your lordship, because no one has supported.
Mm.
Your lordship will kindly see the statement of PW 2126.
Deepolal Hojai?
Yeah, the person who resigned.
Yes.
Paper book, volume 3.
Mm.
Page 625. Page 625.
6255.
Huh.
Yes.
My lord, fifth line is for Lord Security. Till 26 November 2008, I was
Yes.
CEM. Sixth line from the bottom at 625.
Yes.
Till I took over as CEM of NC Hills Autonomous Council in the month of January 2008. Till 26 November 2008, I was CEM. On 27 November 2008, I submitted my resignation from the post of CEM on health ground because myself and my wife were ill at that time. The person who submitted resignation, he is giving reasons, and all other witnesses. I can just, my lord.
So maybe you can elaborate tomorrow. We'll continue tomorrow.
Right.
Because now it's 4:15. If you want, you can complete discussing the statement of
Yes.
this witness right
Yes.
now.
Now, my lord, your lordship will just somewhere your lordship put in PW 23, 20, 23, 79, 81, 82, 87, 98, and 126,
Yes.
129. They all have been declared out of 9. 8 have been declared. And 9 is PW 23. He has not been declared.
Not been declared.
Just read the statement and I'll close for the day.
Right.
My lord may kindly come to volume 1, page 77.
Page 77. Yes.
Paper book, volume 1.
Yes, we are. I mean, Kulendru.
Kulendra Dolabhu.
Dolab. Yes.
My lord, he has not been declared hostile. That's the thing when what he says.
Yes.
The last paragraph at page 177. During one of the meetings, maybe sometime in November
yes.
2008, Deepolal Hojai cited his ill health and offered to resign from the post of CEM of the Hill Council. Subsequently, his resignation was sent to His Excellency Governor of Assam, which was accepted, and after that, Mohit Hojai was elected.
Yes.
So even he says that he resigned on his own account. My lord. Now he has been declared hostile, and all his statement under 161 has been put. And this, my lord, will see at this is at the discussion about this witness is at 126 is at page 195. That I have taken your lordship. So he doesn't say anything. Nobody says that he is forced to resign. But on 413, your lordship has seen. The trial court has said that it is proved. Chronologically, they have proved this, that he was over or was made to resign. Continue tomorrow.
Oh, yes. Arguments heard in part. List tomorrow for further hearing at, we can fix it at 2. We can fix the hearing at 2.
At 2.
At 2.
Yeah.
Right, at 2 p.m.